SJC-11373, Commonwealth v. Heather M. Duncan.
Yes, counsel. Good morning.
Good morning. Good morning, Mr. Chief Justice, and may it please the court. A district court judge has asked this court for guidance in applying the appropriate constitutional principles to an emergency involving an animal in immediate need of assistance and protection and in imminent danger of physical harm.
Can I ask you what it is that we're being asked to decide? Is it clear? Because it seems that in the red brief, there's some challenge to whether or not this was, in fact, an emergency. Has the judge determined that it was an emergency, and the only question is whether or not there is the emergency aid exception to the search warrant rule would also encompass animals as well as humans? Or is it that both of these questions are before us, that we're to determine whether or not it is an emergency as well?
The question reported in the formal report says, does the emergency exception to the warrant requirement extend to animals? There's a footnote in the discussion, which is included in the larger findings of facts and rulings of law, that contains the compound question that my brother points to suggest that the judge didn't actually conclude that there was an emergency. I'm happy to talk about the reasons why there was an emergency in this case.
So if that's the case, is it let's assume for the minute that the answer to the question is as you want, that is, that the emergency exception applies. Is it your contemplation that this would go back for a determination whether there was, in fact, an emergency that would make this applicable?
No, Your Honor. The compound question, and this is what I'd like to sort of drive home, it was simply an acknowledgement of the procedural path that this case took. When a question is reported, this court has not been shy about answering preliminary or subsidiary questions before answering the ultimate reported question. And of course, in a case that hasn't been addressed in the Commonwealth before, it's our position that existing case law provides no guidance in this area. I think it's just an acknowledgement by Justice Flatley that this court may want to sort of look under the hood and to talk about whether an emergency in fact existed.
Okay. And what is the rule which you say we should apply?
On the question reported or on whether there was an emergency?
On the question reported.
It is our position that the carefully delineated emergency exception to the warrant requirement provides enough protection against unreasonable searches and seizures in the context of animals as it is in humans.
Okay, for any animal?
That's correct, Your Honor.
So a lobster being put into a lobster pot?
There are, the prohibition, the Fourth Amendment prohibition, which is the same as the Article 14 prohibition, is against unreasonable searches and seizures. And there will certainly be jury questions, motions to dismiss, and other ways to ferret out, that's a bad turn of phrase.
I was going to say.
To turn away questions involving unnecessary cruelty, which is what the animal cruelty laws prohibit, related to ants, related to dragonflies. But I think some of the amicus briefs point out that ripping the wings off of a dragonfly is different from sort of pulling apart a bald eagle. And it would be...
Maybe not to the dragonfly.
That's absolutely true, Your Honor. And there's a case from Oregon in September that took a different approach, and it's certainly one that this court could. It added to the doctrine, a genuine emergency must provide officers with an objectively reasonable basis to believe that an animal is in injured or in imminent danger of physical harm, simply changing human to animal in that requirement. The police must act reasonably to assist or protect the animal, and it adds the following language, creating essentially a different exception. It adds serious physical injury or cruel death unless that injury or death is being inflicted lawfully. So if the conduct is lawful, that would permit people to fish, to farm, to do animal husbandry practices like dehorning that are important in farming. Factory farming would be allowed, but it would conform with our societal expectation that the conduct alleged here that occurred in the defendant's front yard of her residential home within the curtilage in full view of the neighborhood was prohibited, and it was permissible for the officers to act to save the life of the last living dog in mortal danger.
So we're really, I mean, are we really talking about domesticated pets, be they horses or dogs or cats? Or, I mean, is that what we're really talking about here?
In this case, yes. That's not the question reported, and that's not the full scope of the animal cruelty statute, which protects wild animals as well. Certainly, this same situation could have happened to a raccoon and been just as, appalling to the concerned citizen who reported this conduct to the police in the first
But
place.
presumably it would be, again, the raccoon would be domesticated. I mean, if you want to reproduce these same circumstances, that is, living within the curtilage and seen over a couple of days, et cetera.
I'm not sure that's true, respectfully, Your Honor. I think certainly someone, because it's a failure to provide by a custodian case, that's correct. You're right. In this instance, that wouldn't fall under the specific provision of the animal cruelty statute, which the defendant is alleged to have violated, which is failure to provide by a custodian. Right. There are cases in other jurisdictions, of course, that involve the direct infliction of pain, and that would maybe be a better example of the raccoon issue, wild animals.
So there has to be human involvement, in other words, in order for the exception to apply. I mean, you can't have. I don't think you're advocating that, for example, if an officer happened to observe the coyote eating the family cat, that the officer could go on the property to save the cat.
I hesitate to say that could never be the case, because let's say that someone trained a coyote over a course of time to attack a specific cat, and a defendant, I don't think, should be able to say that the intervening cause of the coyote going after the cat.
There's human involvement in that. I'm talking about wild animals. Something about nature can be awfully,
Violent, yes.
Yes. So, but that wouldn't be within the purview of what you're suggesting.
Perhaps. Certainly the Suss case, which is I believe the Second Circuit case, maybe the Seventh, seems to say that, when a cat is stuck between two closely adjacent buildings and there's no evidence of any human misconduct, not only is it unreasonable to knock down the entire exterior wall of the building, the police action isn't reasonable, but maybe this isn't an emergency that that version of the emergency exception of the warrant requirement.
So that does support what Justice Lang is saying. I mean, because it's the no human involvement.
That case does. I'm not sure, as a blanket rule, the rich tapestry of situations that seem to arise in these cases, that something wouldn't happen where a human might be responsible for what was going on without having acted. This is certainly an omission case. There could be others.
Well, what do
I'm
they
just not
do
able
in
to
other
comment.
jurisdictions?
I'm sorry?
In other jurisdictions?
Sure. So it's a Commonwealth position that this court should join the 16 other jurisdictions that have permitted, or I guess avoided, the absurd result that the judge essentially handed down in this case, which prevented the officers and would have had them stand right outside the Fourth Amendment protected space and watch the last living dog end up just like the other two next to it, frozen in the snow.
When you say 16 other jurisdictions, are there, I know I should know this, but are there others that actually, is it that others haven't reached it or others have affirmatively rejected it?
No jurisdiction has foreclosed the possibility that the emergency exception to the warrant requirement could apply to an animal in mortal danger. 9 states, the highest court has said essentially what we're asking here. There are 7 others where a trial court or an appeals court has affirmed a trial court's ruling. Many of those have been cited by the higher courts in the other states. Some of them are unpublished, but there's some question as to whether the applicability extends to the whole state. In the federal courts, the U.S. government obviously doesn't have a general police power, so the animal emergency exception is normally discussed when holding that police officers were entitled or not to qualified immunity from USC 1983 claims that they violated the Fourth Amendment by conducting a warrantless search. In dicta, as I mentioned, none of those jurisdictions has foreclosed the possibility that there might be an exception recognized there. They have said that there wasn't an emergency in some instances, and they have said, as in Suss, that the police actions weren't reasonable.
But is there, I mean, the emergency aid exception is a very narrow exception, and when you're dealing with humans that are in jeopardy, there are humans to testify ordinarily to what happened. Here, when you're talking about police coming in without a warrant to rescue animals, the trouble, it seems to me, is going to arise in situations that what else are police going to see when they come in? It's not just for prosecutions under the animal cruelty statutes, but they're going to find the marijuana plants growing, the meth lab, and even though it will fit within, they didn't go there looking for that, they come across this because it's in plain view and so forth. And there'll be no one there to testify. There'll be no witnesses other than the animals.
Well, in this case, Your Honor, there's no evidence of any pretext for the entry.
I understand that, but we're talking about developing a rule.
Absolutely. I don't think even in the human context, where the officers are searching for what they think may be a dead body that obviously couldn't testify as well, that this court has drawn the rules so narrowly as to exclude any plain view observations. And I don't know that it needs to be any different for this specific exception just because the victims can't testify that, oh, yes, well, my marijuana was over there or not, or my owner's marijuana was over there or not.
So the very nature of an emergency exception means it has to be executed in an emergency, which means it needs to be clear enough that officers can act upon it. So what is the clear guidance that you ask us to give to police officers in these situations as to when they can and when they can't?
I think it can be the same as for human emergencies. And
But then we get to the issue of whether it's all animals or not. I mean, are we going to limit it to certain kinds of animals, or are you saying we should not?
I think it's difficult to put a hierarchy of animals in place in a hypothetical scenario. Certainly, our society is less tolerant of cruelty toward dogs than any other animal. And so it's sufficient in this case to answer, yes, the reported question, the question reported, does the emergency exception for the warrant requirement apply to an animal, a dog in this case? Yes. In other instances...
Right, if we do that, there'll be a million cat lovers who will be very unhappy with us.
Not to mention the horse lovers.
Do we not give guidance that applies beyond the particular species we're dealing with here?
This court's free to do that. In other states, they've simply said, it applies to animals, specifically the animal in this case. It's been a dog, it's been a horse, it has sometimes been a cat. I don't know that the sky's fallen.
But I mean, I don't think we can accept something that if somebody wants to enter somebody's house, they wait till they purchase a lobster and then they race in to save the lobster and so that they can get inside the house. I mean, that's not going to be an acceptable. So we need to find some appropriate limits beyond all animals.
Well, the limits are that the conduct has to be unlawful. At least that was the case in Oregon, the case from in September. So the limits may not be species
Well, that's
specific.
actually quite limiting. So then the dog just happens to be very ill and without any indication that there's been any crime committed would not apply?
Well, if someone was a custodian of that dog and failed to provide it such that it was ill, that would be unlawful.
I take it there was probable cause here found, right? Based on just the police observation, probable cause to believe that there was a crime committed, animal cruelty.
Yes, I do want to address the probable cause and exigent circumstances exception because the judge did find probable cause. We believe she also found an emergency. But in this case, exigency does not equal emergency. Certainly the Ortiz case from 2002, which was a murder case where a crowd was sort of outside a defendant's fruit stand or fruit shop and seemed to be sort of wondering where their relative was, and they were about to go in, and the police officers were justified in entering on both. So the emergency exception and the probable cause and exigent circumstances exception can exist at the same situation. Here, I just want to make clear that the Commonwealth didn't ask Judge Flatley to report a question as to the probable cause and exigent circumstances exception because deceased, if this last living dog had died, it would have been more persuasive evidence of animal cruelty. There would have been 3 dead dogs that were malnourished. That's more persuasive evidence, not vanished evidence, evanescent evidence, like the exigency and the probable cause and exigent circumstances exception. And so that's why, in addition to what we feel is the police acting in their community caretaking role, that it's important that this case is justified on the emergency exception as opposed to another warrant requirement exception. I would just ask this court to answer the reported question, yes, and I thank you for your time.
Thank you, counsel.
Good morning, Travis Jacobs for the defendant Heather Duncan. The defendant submits that the Commonwealth's argument actually demonstrates 2 key points. One, how untenable extending this exception to animals would be and how much it would erode Fourth Amendment protections. And 2, it demonstrates how the decision to make that extension should actually be in the hands of the legislature and not the judiciary. With regard to the second point, the legislature has demonstrated that it has demonstrated its authority over the protection of animals generally. We already have a statute that allows warrantless entry into places where exhibition of fighting animals is taking place. If you review certain case law, it indicates that
If a police officer sees what's obviously a stray dog experiencing excruciating pain on somebody's porch, can the police officer enter the property and take the dog without a warrant?
I disagree, no. And there's really sort of 2 problems with using this case and that hypothetical that you've just presented. The first is that in this case, there really was no emergency. But in the second situation, the example you're giving, there's not going to be a 6-foot fence blocking off the entire property.
But it's still the curtilage.
It's still the curtilage, but how does the police officer know that the animal is in distress? It's so subjective. And you may have a particular police officer, say, who's a member of PETA, right? And who has a very heightened sensitivity to animal distress. And so they're going to act on that heightened sensitivity in more circumstances than a police officer who doesn't have that heightened
But our
sensitivity.
facts here are you had 2 frozen dogs, didn't you?
You had 2 frozen dogs, but they're property. A recent case from 2012 in Massachusetts involving the injuries that a person's dog sustained. The court said that animals may have maybe a heightened property. They called it a special purpose property, like an heirloom. And they awarded damages that weren't the difference in value of the property from before the injury to after the injury. They awarded the vet bills only. With regard to...
Well, can we just stay on this for a moment? I want to make sure I understand this. So the police officer observes 2 frozen dogs and 1 very malnourished, whimpering dog. You say there was no emergency. Wasn't there?
Correct. Because if this were an actual emergency, the police would have hopped that fence, popped that lock in 2 seconds and been in there and grabbed those dogs. They waited for an hour and 45 minutes before the padlock was even broken.
One could say that they were trying to act reasonably, which is A, first of all, contact the owner, and B, then get the fire department over there to break the locks and let them in.
But isn't
Know what happened in that hour and 45 minutes, other than that successive steps, as Justice Cordy was talking about, happened. The whole thing took an hour and 45 minutes, and it was at the end of the hour and 45 minutes, animal control left. So there were a whole range of things that were happening in that period of time.
Isn't that the exact definition of what's not an emergency? If you have time to take the, if you have the
Do
time
we know
to,
what happens when an ambulance comes to take care of a human being, how long the period of time is between the time that the situation is discovered until the ambulance leaves? Could be any number of factors that account for the passage of time. You judge whether or not something is an emergency by the length of time it takes to deal with the emergency?
I think you judge whether it's an emergency or not by how quickly the officers respond. And in this case, they didn't respond quickly.
Is there any indication that they were trying to figure out whether they had authority to do this during that time?
There's no indication in the record that I know of that they were trying to determine whether they had the authority. It is sort of interesting to note in one of the amicus briefs submitted by the Mass Chief of Police Association that there are guidelines that actually tell the police that they acknowledge that that the emergency exception has not been extended to animals, yet they still advise police officers and law enforcement to make warrantless entry anyway. And that point actually translates into the untenability of extending this exception. It's first, it would be so broad, the definition of animal, for example, the ASPCA's amicus brief revealed that animals have been defined as everything from a goldfish to a fox in a cage.
So why don't we limit it to traditionally domesticated animals, mammals?
Well, we could do that, but it still becomes a question of if I have a ferret, or if I domesticate a squirrel, or what if I domesticate a turtle?
Traditionally domesticated mammals, that is, those which have a long history of domestication.
Well, so let's say you do domesticate a ferret and that's your pet. Why should that?
Because pets don't have constitutional rights. We're not protecting the constitutional rights of pets here. We're protecting the constitutional rights of people. People have Fourth Amendment protections from unreasonable search and seizure, not the animals. So what you're doing is you're bootstrapping, or you're failing to bootstrap the Fourth Amendment rights of people onto the animals.
But it's not the
No,
Fourth
no.
Amendment right of the
Right.
person who's suffering that's causing the emergency. It's the Fourth Amendment right of the property owner, perhaps, saying that, but the police have the right to respond to the emergency of another human being, not the defendant.
Correct.
And here, is there a societal interest in rescuing animals that rises to the level of an exception of the Fourth Amendment?
There's certainly a societal interest in protecting animals. The Commonwealth and other amicus briefs have shown that there are numerous statutes protecting animals, but there's also several statutes that allow killing animals. There's statutes that say if an animal attacks you and you're standing there or walking, minding your own business peaceably, you can kill that animal. There's still statutes on the books that say if an animal is worrying your fowl or your cattle, you can kill that animal.
Well, that's the same is true with self-defense for a human being.
But we're not talking about human beings. We're talking about animals that don't have constitutional protections.
But aren't we talking about what the reasonable concept of community caretaking is and societal values, as Justice Spina says, that gets included in that?
But you have to ask yourselves, is society willing to erode their Fourth Amendment protections and open up this broadly applicable exception to the warrant requirement in order to protect animals?
Well, can it be reasonably narrowed to certain species of animals and preserve the interests in the Fourth Amendment and preserve the societal values for protecting animals?
Unfortunately, I believe that once you open the door and you start using language like traditionally domesticated animals, that definition is going to change and become broader and broader. And you will ultimately face the same problem that I'm suggesting we face today, which is that it becomes so broad an exception that you're essentially allowing law enforcement the ability to enter any home if they believe an animal is in distress. And that's another thing, too. We're talking about animals in distress. So if you look at 272, Section 77, it says that it's a crime if you fail to give an animal necessary sustenance or food or protection from the weather. So if you leave your house for the day, you don't know it's going to rain, you put your dog in the backyard, and it starts to rain that day, and you forget to put the doghouse out, or the dog's unable to get in the doghouse, is law enforcement now entitled to enter your property, enter your home, and search and seize?
Well, that's our question to you. Why shouldn't that be appropriate? The dog gets struck by lightning, the owner's away, and it's there visibly in pain, obviously in pain. Does a police officer have the right to go onto the premises and to rescue the dog?
But we're talking about two different things. I'm talking about a distress. You're talking about a catastrophic destruction of property. If you have a catastrophic destruction of property, like lightning strikes your dog, or your house is burning down, or your house is flooding, the police are already, or fire department's already going to have the ability to enter and save the animal. They already have that right.
If the lightning just strikes the dog, they have the right? Not the house, not the...
What I'm arguing is the exception that the Commonwealth is asking for is so broad, and it would encompass distress. So you're trying to determine and comprehend what is a distressed dog or what is a distressed cat.
Well, but what I think what we're asking is, you can cabin this, but you seem to be saying there's no cabining possible, correct?
I'm saying there's no cabining possible because I don't believe that society has reached a point where it would feel that it's reasonable to give up and erode their Fourth Amendment protections for the protection of animals.
Is there another jurisdiction that agrees with you?
Well, the Commonwealth and numerous briefs have said that 16 states have found in favor of the Commonwealth's position. But that leaves 34 other states that have not.
There another state that has announced a rule that agrees with your position?
Not that I'm aware of. But that
So
doesn't
we would be the first state.
Massachusetts would be the first state, as far as I know. And
Standard bearer.
exactly. The standard bearer for protecting the citizens' Fourth Amendment rights to freedom from unreasonable search and seizure. We're literally talking about the right of law enforcement to enter a home without a warrant, simply because an animal is in distress. And even if we try to cabin it as certain animals, the number of people in the Commonwealth who have pets is enormous. So if you're looking at it from a societal, does society place enough value on animals to justify eroding Fourth Amendment protections in that way? And the defense argues that it does not. That would be such a broad erosion of Fourth Amendment protections, and it would be so widely open to abuse as well. I understand that that's not the position here, that it was not used as subterfuge, but imagine down the road how much the law enforcement could use that as subterfuge to enter homes without a warrant.
But
And
is
this
it really any different than any of the rules that we already have? And it's a very narrow exception for emergency aid. And it has to be in situations where it is not used as an investigative tool. And, you know, we're always looking at the reasonableness of this. How is this really any different than a fact-based, situational inquiry into whether or not what was done was in an emergency situation, was a reasonable response, was in all of the circumstances reasonable? How is it any different than the doctrine already in existence?
Well, I don't think that's what the Commonwealth is asking. They're not asking for a non-investigatory entry.
I think they're looking
seizure.
for the same as in the emergency aid doctrine as a whole.
Well, that would be the community caretaking function. If you're not going to have an investigatory purpose, right, as far as I understand.
Emergency aid, you think, has an investigatory aspect to it?
Because we're talking about an exigent circumstances emergency exception to the warrant rule.
Well, that the warrant rule is always the question.
And in this,
This is an emergency exception to the warrant rule, really pursuant to the police exercising their community caretaking functions.
Right.
Have I got it wrong?
well, the purpose in this case was investigatory.
No,
How can you
it
say
was
that?
to get the dog.
If they're going to go inside and save the dog, then they would have called the vet. There was no veterinarian
Wait a
call.
minute, wait a minute. I don't.
Call the animal control.
Oh, an hour and 45 minutes later.
But that's I would just say that's a separate issue. I mean, I think, as Mr. Wagner says, and you've suggested, one issue is, was there an emergency? The other is, assuming an emergency, do animals fit within the scope of the emergency aid doctrine?
Well, I mean, I certainly understand the question, and my argument is that it absolutely does not. That the Commonwealth is asking this court to extend the exception to the warrant rule to the protection of animals. But it's too broad. The request is too broad. It's for the distress of animals, which is too subjective. How do you tell what a distressful meow is or a distressful bark? You can't then have the cat or the dog come into court and testify that, yes, I was in distress, I was injured, and I needed aid. You don't have that.
Well, I mean, you don't, that's all part of the reasonableness inquiry. If a child was screaming, some people would hear that as, in one way, other people would hear it another, and ultimately, if the police entered, they would have to justify the entry.
But we're also talking about people again. People have constitutional protections. Animals do not.
We're not talking about the child's constitutional protection.
But we are.
No, we're talking about the search requirement, which belongs, the right belongs to the person whose property is searched.
And in that situation, if you have a human baby that's crying and there's a reasonable belief that that baby is in distress,
It's the reasonableness inquiry that, the police enter and they have to justify the entry, and that's not different, I think, than what the Commonwealth is requesting here.
but babies have constitutional rights, they have constitutional protections just like adults. The animals do not. Animals are
I think
essentially
we're talking
property.
at cross purposes here.
Well, folks, we're going to have to leave it here. Thank you, sir.
Thank you.